Contract law in ancient Greece. Contract law in ancient Greece reflects the complexities and nuances of its city-states, with Athens being one of the most documented examples. The Greeks developed a system of laws and practices that allowed individuals to enter into agreements, with mechanisms in place for enforcement and dispute resolution. This system facilitated commercial activities, property transactions, and personal agreements, contributing to the economic and social dynamics of Greek society. Key aspects of Greek contract law. Written and oral contracts. Ancient Greeks recognized both written and oral contracts. However, the importance of written contracts increased with the complexity of transactions and the need for precise terms. Public notaries or scribes often recorded these contracts, especially in significant transactions involving land or large sums of money. Role of witnesses. Witnesses played a crucial role in the validity and enforcement of contracts. Their presence added credibility to an agreement and was crucial in case of disputes. Witnesses were often required for the contract to be considered binding. Types of contracts. Contracts in ancient Greece covered a wide array of agreements, including sales, leases, loans, labor agreements, and marriage contracts. For example, in Athens, dowry agreements were common in marriage contracts, specifying the property or wealth brought by the bride into the marriage. Enforcement and dispute resolution. The Greek legal system provided avenues for the enforcement of contracts and resolution of disputes. In Athens, for instance, the magistrate, or a relevant official, could initiate a legal process if a contract was breached. The courts played a significant role in adjudicating disputes, with jury courts being a common venue for civil cases. Legal reforms and contributions. Solon's reforms. The Athenian lawmaker Solon introduced significant legal reforms in the early 6th century BCE, which impacted contract law among other areas. Solon's reforms aimed to balance power among Athens' social classes and included regulations on debt and economic practices. Commercial laws. Given the importance of trade in Greek city-states, especially in maritime powers like Athens, specific laws governed commercial transactions. These laws regulated trade practices, maritime loans, and shipping contracts to support and protect merchants and sailors. Philosophical influence. Greek philosophy, notably the works of Plato and Aristotle, also touched upon concepts relevant to contract law, such as justice, fairness, and the nature of agreements. While not legal texts per se, their philosophical discussions influenced Greek thought on the legal and ethical aspects of contracts and agreements. Differences among city-states. It's important to note that what we know of ancient Greek law, particularly from Athens, may not fully represent practices in other Greek city-states, such as Sparta or Corinth, which had their own legal codes and practices. The Greek world was diverse, and local customs and laws varied significantly. Legacy. The contractual practices of ancient Greece contributed to the development of legal thought in the Western tradition, especially through the preservation and study of Greek texts during the Roman era and the Renaissance. The emphasis on contractual agreements, legal processes for dispute resolution, and the role of law in economic and social relationships in ancient Greece laid foundational concepts that influenced subsequent legal systems in the West.